Has the issue with Mr. Knapp been resolved?
No, Your Honor, but we'd like to proceed a different way if possible.
Okay.
The defense would like to call Mr. Andrew Savage to the stand. He will testify to the same things that Mr. Knapp will testify to.
To call who?
Mr. Andrew Savage. And that's provided it does not disqualify him from the remainder of the case, Your Honor.
Hear the state's argument on that issue.
Thank you.
Can't serve as a witness and counsel.
Your Honor, I would just point out that he's not a witness to any of the pertinent facts that relate to the case itself. This is a pretrial matter, much like we had testimony from counsel earlier in the case.
Says the state.
No objection.
All right. Proceed.
State calls Andrew Savage. Pardon me, the defense calls Andrew Savage. I'm so used to hearing it the other way around.
Swear affirm the testimony you shall give the court will be the truth, the whole truth, and nothing but the truth, so help you God. I do. Thank you, sir. You state your first and last name, and spell your last name loudly, clearly to the microphone.
Andrew Savage, S-A-V-A-G-E.
Good afternoon, Savage.
Good afternoon.
Where are you currently employed?
I work for the Savage Law Firm in Charleston, South Carolina.
And what is your role there?
I'm an attorney.
What is your connection to this case?
I represent the interest of Michael Slager.
When were you retained or hired or contacted to represent Michael Slager?
April 7th, I believe, of 2015.
And
Maybe April 8th.
April 8th?
Yes.
When you assumed representation of Mr. Slager, did you at the same time or near that time observe any media coverage of the case?
Yes, I did.
And did you continue as time went by to observe media coverage of the case?
Yes, I have.
At some time, did you receive information related to the case from the state?
Yes.
And how did you receive that information?
Verbal, written. The solicitor's office and our office has had almost daily exchanges of information.
And as you received the information from the state, did there come a time where you began to question the version that you saw in the media?
Objection, Your Honor.
Let me rephrase, Your Honor. I'll rephrase, Your Honor. Did you receive a copy of a video from the state?
Yes.
Was that the same video you had seen on the media?
Your Honor, objection. Will we approach it?
Okay.
Your Honor, may I approach the witness?
Yes, sir.
Mr. Savage, the state has stipulated that when the video is shown, it is sometimes and oftentimes a truncated version of the entire video. Did you observe that? Did you do anything about that?
Well, I just really wanted to talk about the media. And my connection and my representation of Mr. Slager, I'm obligated, in accordance with our rules, to ensure that he obtains a fair and impartial jury. And in that respect, we have monitored the media, and in accordance with the media reports of the Post and Courier initially, I had numerous contacts with Mr. Knapp, and Mr. Knapp and his supervisor, Mr. Pugh, and I'm pleased to say that they have included information in their reporting that was not there for the first many months. That's really all I had to say with Mr. Knapp, is that the initial reporting was inadequate. It was truthful, but it was not complete and therefore provided a false narrative. After speaking with Mr. Knapp and his superiors, that information was changed to be more complete.
Got further questions, Your Honor?
That's good.
I just have one. You've had no difficulty getting out your message to the Post and Courier, have you?
Well, I'd like to be their editor, but as much as I could advocate on behalf of Mr. Slager, I would say that the News and Courier is very responsible.
Yeah. You haven't filed anything in the court that they haven't published, correct?
I'm not sure of that.
You had a full-page ad or a full-page story in the Post and Courier this past Sunday, correct?
I had no idea. I didn't read Sunday's paper.
And you had an interview with Miss Carolyn Murray this past weekend, correct?
Yes, I did.
And so you've had no difficulty with the media getting your position out into the public?
Well, I wouldn't say that's correct. The overwhelming media coverage of this case arising from every area other than your office, frankly, it was a tsunami of information. Those of us that are old enough to remember Jack Ruby, it's the same type of video where conclusions could be drawn from the video. The difference between Mr. Ruby's case and Mr. Slager's case is that there was a lot of information prior to that moment that was just didn't fit the narrative, so it was not published.
And there's no question that the news coverage in this case has been prevalent, is it correct?
Yes.
Most of it occurred back in April and May of 2015, is that also correct?
I don't think so, Mr. Durant. That's the reason why I thought it was important that we said there were 1,800 in the Post and Courier daily publication, 18 months, 1,800. Messages that contain Slager and Scott. It's extraordinary. And the whole point of this is, frankly, is not to blame the media or blame the court, but to just say that the information that was provided in this case is much greater than I think this community has ever seen, and that a good portion of it was incomplete. It's not to say it was false, it's to say it was incomplete.
And would you agree you've been through jury selection these past 2.5 days, that we have come up with a pool of jurors that basically have testified under oath that they could decide this case based upon the evidence presented in this courtroom, applying the law as charged by Judge Judy?
That is correct.
Thank you.
Nothing further, Judge.
Let me step down.
Should I call the next witness?
Yes, prior to doing that, Rule 3.7 of the Rules of Professional Conduct states that a lawyer shall not act as an advocate at a trial in which the lawyer is likely to be a necessary witness unless the testimony relates to an uncontested issue, relates to the nature of legal services rendered, or 3, disqualification of the lawyer would work substantial hardship on the client. Commentary to that rule goes on to say that a witness is required to testify on the basis of personal knowledge, while an advocate is expected to explain and comment on evidence given by others. The tribunal has proper objection, and the trier of fact may be confused or misled by a lawyer serving as both advocate and witness. The opposing party has proper objection where the combination of roles may prejudice that party's rights in the litigation. It's always a concern and a slippery slope when the lawyer seeks to act as counsel and a witness. In this instance, and considering the limited testimony solicited and there being no objection by the state, the court allowed the testimony. You may call your next witness.
Thank you, Your Honor. Mr. Cranford?
You swear or affirm the testimony you shall give the court will be the truth, the whole truth, and nothing but the truth, so help you God? Do. Please state your first and last name and spell your last name loudly for the illusion.
First name is Carey, last name is Cranford, C-R-A-N-T-F-O-R-D.
Good afternoon, Mr. Cranford.
Afternoon.
You're a resident of South Carolina,
Yes,
Richmond County,
yes.
and what type of business?
I own and am the principal in a market research, trial consulting business.
And with respect to the trial consulting business, what do you do?
A variety of things. One of our special skills is qualitative research, which is small group discussion panels where we bring people in to listen to what they know or understand about a particular event. This is something that's not necessarily limited to trials, but is also, we do this in consumer areas as well. But essentially to understand how consumers or in our trial area, people in the community may be reacting to information that may be in the news or reacting to information that may be in terms of advertising, communications in general.
Same principles that would apply to marketing in terms of sales of the product, community feelings about that campaign, advertising campaign, and the product itself can be applied to jury selection. Is that
Very much so. I mean, it's a behavioral analysis. It's also what's referred to as a phenomenological analysis in terms of how people see themselves, how they see their surroundings, and how they see information fitting into that.
were you hired by the Savage Law Firm?
We were.
You worked on the case involving the state and the United States versus Michael Slager?
We have.
And tell the court, if you would, what capacity, what type of objective were you asked?
Initially, back in the spring, because of the uniqueness of, the reason we were hired, because of the uniqueness of the publicity of the case, its linkage to national issues, the amount of media coverage which it was receiving everywhere with it, there was some interest in trying to find out how people in the Charleston marketer community were reacting to this, how they were assessing it, what were they looking at, what were they paying attention to, how often or had they seen the information that had been in the media, and what impact it was having on opinions. So our first task was trying to assess what the initial press information that was out there about the case and how it was shaping attitudes about the case.
Is there a difference between the term media and press? Does press limit that term?
I don't think in today there may be in terms of certain professional groups, but
talk about both print and electronic.
we'll talk about communications in general as the correct
Now,
topic.
with respect to the marketing area of Charleston, does that overlap the Charleston County line?
Oh, absolutely. It's the key.
So if you would, for the benefit of the court, if we talk about that,
Sure.
we do explain to the court what we're interested in is in Charleston County jurors, not in the meeting hall.
Correct.
With respect to that, did you conduct any focus groups?
Right. The initial 2 focus groups that we did back in the spring was to try to determine the levels of awareness and whether or not, without argument, whether or not there were opinions being formed based on the level of awareness that was out there.
Without going into any of the details of decisions or factual matters that they were presented with, tell the court, restrict it, please, to opinions about the case, if they acknowledge the case, that sort of thing.
In the first 2 groups that we did early on, 100% of the participants who came in, and they were recruited blindly. They were also screened to make sure that they had nothing to do with law enforcement or various other occupations that would touch on this, including the media. 100% of the participants knew about the case, were aware of the case, had seen information about the case. So initially, as we started our probe, we knew that our panels had a good bit of information from their perspective, not necessarily my perspective, but from their perspective, a good bit of information about what happened.
With respect to any other work you did after the focus groups?
We replicated another one much later, and we found the same dynamic. We also conducted a quantitative survey in Charleston County in September, where we asked the same question to try to get a sense of where this was after this time had passed. And then you have to say, since we're researchers, the visual information which we saw yesterday in terms of people standing up that were aware of it. All of those incidents showed 90+% of people that were involved in the research studies, or even as we saw, I don't know, it was 90% yesterday, it was the vast majority, were aware of this, had seen information about it.
Without going into the detail of the push and pull, what did you find regarding existing opinions once established and how fixed they were?
Opinions of focus groups on what issue?
Ability to, number one, what's the depth of the media impact that you've had, what decisions based on that media they formed, and how difficult to overcome. Well, leave off the third.
Okay.
Just tell us if they had media coverage, as a result of the coverage that they formed an idea.
It goes in two stages across all the forms of research. Awareness created opinion. It was I've seen something, it's very dramatic, you know, it's there, I've seen it more than once, I've seen it over time, and I have an opinion about it. So,
The state objects, I believe at this stage, the only relevance here is our jury panel that we've yet to swear, but that we've been paneled at this point, and whether or not they can put aside those opinions. I'm not sure the relevance of polling of people that are not on that jury panel.
The opinions of focus groups are not relevant to this issue before the court, and I sustain the objection.
As a result of the focus groups and the survey that you took, did you consult with the Savage Law Firm regarding the best way to elicit opinions of potential jurors?
yes, or important information for potential jurors, yes.
And did you explain to the court what type of questions did you recommend, the basis for that, and the method in which the question should be asked?
Well, let's go through the types of questions first. A general type of questionnaire on this specific case, and we'll talk about the jurors that stood up, who said that they, yesterday, or the other day, as they stood up and said they went and looked for information on this case because they were served or they found out they were going to be a juror. That was a significant number. That's what happens, is when people think or connect with this, they begin some sort of method of search, discussion, or what have you. We saw a lot of jurors during the qualifying say they discussed not only with the sheriff's deputy, people at work, friends, whatever. So there are opinions, information entering into the juror's mind that have nothing to do with their employment, their particular background, their age, where they live, and things like that. So we were recommending questions that got beyond kind of the basic behavioral experience and into deeper interactions between jurors and potential sources of information about it.
What would be the method that you recommended to pose those questions?
How you ask a question is very important to the answer that you get back. Where you ask a question is also very important to the answer that you get back. The best and tried and true method that you'll find textbook is that the questionnaires of these types of things are done individually, privately, without any other influence around them, and certainly not in the face of a crowd or something, particularly if it's information about their personal background.
Are questionnaires, written questionnaires, given to potential jurors, done so for the purpose of a more thoughtful reflection on the answers?
It reduces something that's called internal, it increases what's called internal validity, the validity of the question, that the respondent is answering with their mind with it. So yes.
There's a bit of object, I think we're veering into expert testimony here, and I don't believe this is qualified to give opinions.
This testimony sounds like appellate review of the court's voir dire process in this case. And that's not for this witness to opine concerning.
Would you tell us as briefly as you can the difference between an individual voir dire in terms of the thoughtfulness, the integrity of the answer as to group speak?
The process, I think, is what I can answer, and is very important. That the setting in which questions are posed,
Object, same basis.
Objection sustained. The statute, laws of South Carolina set forth a procedure in this state for jury selection. It's not for this witness to agree with or disagree with. I sustain the objection.
Kind of answering questions the prosecutor may have.
sure.
Court's ability. The state has no question, Your Honor.
You step down.
Judge, that's all we have, and the reason for this testimony is on the issue of the voir dire. So the case law, the Supreme Court says that the change of venue motion is not appropriate until it's shown that a fair and impartial jury cannot be selected. What we asked for was extensive voir dire by questions. We asked it on 2 separate filings and then verbally in court for more extensive voir dire. And perhaps more importantly was the method of voir dire, which we think that should have been done on an individual basis.
And you've raised that issue, and the court has ruled on that issue. You saw it at more, you
Yes.
filed a motion seeking
Extensive voir dire.
extensive voir dire, voir dire, individual voir dire, every juror, posing them some 150 written questions, 140 or so, over and above what was submitted to them in the mail to complete, in addition to the voir dire conducted by the court, and the court denied your motion.
Yes, and our concern is that the law is that your Honor has that discretion to determine the method of questioning and the extent of questioning and the type of questioning. And we're not challenging the court's authority. All we're trying to establish is support for our position that Mr. Slager should have been entitled to further voir dire so that we...
And that opinion is preserved for the record and could be addressed in perhaps another forum if need be. But on the issue of change of venue, your change of venue motion, it's as if you're seeking to repackage a motion that the court has rejected.
Change of venue is conditioned upon adequate voir dire. So our position would be, because there was not adequate voir dire, I don't say this in any way, Your Honor, disrespectful to the court, but if the jury of 12 has been seated based on their voir dire, we believe that in choosing that jury of 12, we didn't have sufficient information to ensure that Mr. Slager would get a fair and impartial trial. So we're asking post-selection of that jury for a change of venue.
I understand. By the state.
Thank you, Judge. I would just briefly direct Your Honor to Shepherd versus State, 357 SC 646. State v. Evans, 373 SC 404. These are both opinions by the Supreme Court of South Carolina, and they both involve motions for change of venue due to excessive pretrial publicity. Particularly, I believe in the Evans case, the jury was asked who was familiar with the case and had heard information about the case prior to being impaneled. In that case, 39 people of a jury pool of 68 had knowledge of the case. In Shepherd, likewise, the jury was paneled, and 87 potential jurors, all but 5, had been exposed to pretrial publicity and facts of the case. In both of those cases, the Supreme Court affirmed the trial court's denial of change of venue, stating that when jurors have been exposed to pretrial publicity, a denial of change of venue is not error, where the jurors are, as they have been here, found to have the ability to set aside any impressions or opinions and render a verdict based on the evidence presented at trial. Based on those holdings, even in cases, no one disputes that pretrial publicity here has been, quite voluminous. But as those two cases point out, as long as the jurors can swear and affirm that they are able to put that pretrial publicity aside and render a fair verdict, then a denial of change of venue is proper.
Leading case in this area is State v. Manning, where the court held that the denial of change of venue is not error when jurors are found to have the ability to set aside any impressions or opinions and render a verdict based on the evidence presented at the trial. That in determining prejudice from pretrial publicity, the United States Supreme Court looked at various factors, including whether blatantly prejudicial information could not be reasonably shut from the sight of the jurors. And the court found in Skillings v. U.S. that the sheer number of victims or recent publicity, etc., about a case did not warrant an automatic presumption of prejudice. So though there may be pretrial publicity or a significant amount of it, the linchpin of looking at this issue is prejudice, or whether or not the overwhelming prejudice prevents a party from receiving a fair and impartial trial. Manning states that mere exposure does not automatically disqualify prospective jurors, but whether the jurors had such fixed opinions that they could not impartially judge the guilt or the innocence of the defendant, citing State v. Tucker. General practice, as outlined in State v. Manning, is to postpone ruling on the motion until voir dire is complete. Further, the prospective juror's knowledge or information in advance about a case does not per se disqualify the juror. The moving party, in this case the defendant, bears the burden of showing actual prejudice as a result of such publicity. The court cited Kennedy Coates in holding that in deciding whether to change the venue, the court cannot rely on beliefs, opinions, and conclusions of witnesses. In this case, the court engaged in extensive questioning of the jurors on the issue. The court is satisfied that based on the fact that 600 jurors were summoned, some 200 or so appeared. We ended with a panel of 119 jurors who determined that the court and who expressed that they could be fair and impartial. And we've selected 18 jurors who share that same sentiment that they could give both the state and the defense a fair and impartial trial. I'm not persuaded by the quality of the testimony of the three witnesses of the by the defense seeking to show prejudicial pretrial publicity, and I deny the motion. Next motion, Ms. Wilson.
It's still there.
I think they have a number of other ones.
All right, Mr. McKinney.
Thank you, Judge. Can I have just a moment, please?
All right. Well, he has a moment. Let's stand for a moment. Get a little stretch in.
I'm hoping that these are both parties, because I've just seen.
It'll take 3 minutes.
Thank you, sir.
Thank you, Judge. We just have a few motions in limine. Some aren't ripe yet. I don't think this will take too much of the court's time. I think we've agreed on the substance of some of the motions, and others of them will require a brief argument, if any. So we have filed a motion in limine regarding admission of evidence. It was filed on the 17th of October. And it merely requests that before the jury sees any photos, documents, or anything like that, they're properly introduced. And there are some, I believe, some photos that will be shown during the, perhaps in the opening statements tomorrow. I think we have discussed that. We'll discuss a little further in the morning, but I think from the solicitor, we basically agree on that motion with the exception of the opening statement.
Yes,
Make sure
sir.
we're clear.
I have some photos in opening that are very benign. One is a map that I might use. Another is just photos from a dash cam that are very, as I said, benign, that sort of help me tell the story. I don't think there'll be a problem, but we can discuss that further in the morning.
In
As
the
far as,
morning, when the jury comes, we're starting with opening statements.
yes, sir.
Not with arguing over what photos the jury can see. So if you have a dispute involving that, let's address it at this time.
Judge, I'd like to see the photos if we could, and they can gather those and we can continue on if that's all right. And
Sure.
we'll address these other motions so we're not hung up on that. We also have a motion in limine regarding mentioning the federal indictment. We believe that would be prejudicial.
Any objection?
No, sir.
It's granted.
We have a motion in limine to prevent reference to the suffering of Mr. Scott or his family as it pertains to the jury's decision on guilt or innocence. We think it's irrelevant, Your Honor, to the decision of whether a crime was committed or not. It may have some relevance in the sentencing stage.
I think Mr. Scott's suffering may go to the defendant's malice. And so I don't agree with that. I don't intend to speak about the family's suffering. But I think that's something that can be brought up by objection with the witnesses if we go to a place that they think is inappropriate.
Now, this type of motion is generally meaningless because some counsel will say, we're sorry for your loss. And does that open the door? No one's going to say that. It's just typically a meaningless type of motion unless you are asking me not to have them plead to the sympathy of the jury.
That is the point of the motion, Judge, not to have them, and I understand that this is a very emotional case, but the jury needs to decide on the facts, and that's the point of the motion.
Yes, sir. Those type motions or objections typically need to be made contemporaneous with some kind of, I cannot outline what words the state can or cannot use. Certainly the rules must be followed, and I'm sure you all will object if they're not followed.
That's correct, Your Honor.
Yes, sir.
I have a motion in limine regarding no comment on the silence of the defendant, and I think the solicitor has no issue with that.
Is that correct?
Yes, sir, I think that's the law.
I have a motion in limine, oh, I'm sorry, Judge.
That is the law.
Thank you. I have a motion in limine regarding the CPR and taser retrieval. After Mr. Scott was on the ground, Mr. Slager went back and retrieved a taser. We believe the evidence will show that's what he is trained to do. He also did not administer CPR because he was not trained to do that. We would reserve the right to object if the solicitor wants to bring those items up contemporaneously with that, because we think it may be substantially more prejudicial than probative, depending on the context in which those items come up.
Right?
Your Honor, is our position that the lack of CPR by Officer Slager at the scene goes directly to his state of mind and malice, contrary to what's been represented. He is trained as a police officer in CPR. Their policy on use of force requires him to administer emergency aid in the event that he uses either deadly or non-deadly force against the subject. And he was a voluntary EMT for 16 hours per week for 3 to 4 years when he was coming up. So the fact that this allegation that he has no training is completely untrue. And secondly, with regard to picking up the taser, had he picked up the taser and holstered the taser after this incident, it would not be an issue, but the evidence will show that he picked up the taser, walked over to where Mr. Scott's body was, and dropped the taser by Mr. Scott's body, which certainly raises an inference of malice on his part and an intent to obstruct justice and or alter the crime scene. I think it's extremely relevant in a prosecution for murder and voluntary manslaughter.
Anything further on this issue?
Yes, Your Honor, I would just disagree with the characterization that Mr. Slager was trained and qualified in CPR. He had done it 15 years ago. I used to be trained to fly an aircraft, Judge, and I'm sure he wouldn't want me flying because I haven't done it in 10 years.
What basis would I have to grant this motion in limine, based on your representations, or deny it based on the solicitor's representations? You want me to make findings of fact on these issues?
Absolutely not, Your Honor. The purpose of these motions in limine now is so that the solicitor and the court and the defense are all aware of these potential problem areas so that we can identify them as they come up. Motions in limine generally come up before trial, but they're not considered until the evidence is presented. And these are just sign markers that we're putting out for the court that there may be some disagreement on these issues. They will be properly objected to at the time if there are disagreements on the issues.
Well, Your Honor, the problem is we have opening statements in the morning in which I'm supposed to let the jury know what our case is going to be about. And part of our case is going to be about the things that Mr. McCune just referenced. Now, granted, opening statements aren't evidence, so I just don't think it's appropriate to limit me from referencing these things in opening statement when they are a critical part of our proof of malice in this case.
The motion in limine is denied.
Thank you, Judge. We have additionally a motion and memo to exclude prejudicial terms. I'm sure Your Honor has seen this motion before. We believe that the Constitution requires that the Mr. Slager not be referred to as the defendant. We think it puts the jury in the mindset that he has to prove his innocence. We believe he should be referred to as Mr. Slager, and we believe as well that Mr. Scott should be referred to as Mr. Scott and not the victim for the same constitutional requirements that Mr. Slager receive a fair trial and that he is presumed innocent until proven guilty.
Mr. Durant.
Your Honor, once again, it appears to be an attempt to overturn 250 years of jurisprudence in this state. These are merely name designations: defendant, victim, state. There's nothing prejudicial in and of the terms themselves. A victim is someone that's killed or harmed as a result of a crime, accident, or other event. That's all that it means. There's nothing prejudicial about it. There's nothing burden shifting about it. The same for a defendant. It's just a name of a party. You know, it's like us objecting to being called the state, because that is the name that our systems of jurisprudence has given this side. The defendant is the name given to the other side. Once again, there's nothing prejudicial about them. There's nothing burden shifting about them.
Just briefly, Your Honor, the South Carolina Constitution, Article 1, Section 24 says a victim means a person who suffers direct or threatened physical, psychological, or financial harm as a result of the commission or attempted commission of a crime against them. And until the commission of the crime is proven, we don't think that the term victim should be used. We will rely on the court's judgment.
And in response to that, Your Honor, that is a definition of victim specifically as it relates to the Victims' Bill of Rights, which solely involves victims of crime as opposed to victims of accident, victims of happenstance, victims of circumstances, the kind of victims that our jury will attach to the word victim.
The jury will be well instructed, thoroughly instructed on the presumption of innocence, the fact that indictment is not evidence, and the burden of proof is on the state. Mr. Slager is the defendant. Mr. Scott is the victim, according to what is alleged in the indictment. I deny the motion.
Thank you, Judge. We have a motion in limine regarding the use of the term homicide. Your Honor, all we're asking in this motion is if someone uses the legal term homicide in describing the death of Mr. Scott, that a prophylactic instruction be given by the court, that homicide is a term of legal art. The public somewhat perceives that the term homicide is associated with a crime, and we have proposed a limited instruction in there that just says that the use of the term homicide gives no inference of criminal wrongdoing on the part of anyone. It's a legal term that simply means someone died by the act, procurement, or omission of another. And we would request that before the term homicide is used, because it could be misconstrued by the jury, that instruction be given.
Once again, Your Honor, it's just a word with the definition, which is the death of someone by another. Can be justifiable, can be non-justifiable. It really raises no prejudice in and of the word, but I can't imagine a situation where I would use the word homicide anyway, but maybe the medical examiner would, but I certainly don't attach any prejudice to it. And if Your Honor thinks that if somebody says the word homicide and you need to give a curative instruction, that's up to you.
We'll have many witnesses using many words, and I'm not sure how those words will come to be as a result of what questions will be asked. I think typically the forensic pathologist might, if asked how did they classify a crime, because quite often that comes up in an inquest or some other proceeding other than trial. We'll address that issue if need be, if and when it occurs, depending on how it occurs.
Thank you, Judge. We have a motion eliminated regarding mention of the state of Walter Scott civil settlement. I believe we have agreement from the solicitor that they don't plan on introducing that.
That's correct, Your Honor.
Correct.
The court sustained an objection to that a little earlier this afternoon.
Your Honor, we have a motion eliminated regarding the number of shots fired. As you know, there were 8 shots fired in this case. The case law in South Carolina is such that depending on the circumstances, if the first shot was justified, subsequent shots may or may not be justified. We're concerned that they're going to be...
Who determines those circumstances?
Well, those circumstances are determined by the jury.
So You said depending on the circumstances.
Well-
So if the jury is to determine the circumstances, then how can I agree with your argument?
Well, the jury could examine the first shot, Your Honor, and then decide from there. The case law out there says if the first shot was a proper use of force.
Depending on the circumstances.
Depending on the circumstances, Your Honor.
Says the state.
I believe you picked up on the same thing I did, Your Honor. They referenced State v. Hendricks in their motion, of course, which is a case where the court found as a matter of law there was self-defense, and the old adage that if you're in self-defense, if you shoot one time, you're justified to keep shooting until the threat is gone. Well, the question in this case is whether Mr. Officer Slager was entitled to shoot the first shot, much less, 7 after that. And that is a jury determination. And also, he's charged with murder. I'm sure there may be a lesser included offense involved voluntary manslaughter. Could go to either one, his state of mind in either one of those, either malice or sudden heat of passion. I think they're relevant to both. It's up to the jury to make that determination.
Denied the motion.
Thank you, Judge. We have a couple motions I haven't mentioned that I don't think they're right yet. We have a
How would
motion.
they be right?
We have a motion about the state's closing, Your Honor. It would be right after the state's closing. We have a motion regarding a view of the scene. I think it depends on the evidence that's adduced and what we can put in front of the jury to make sure that they have an accurate idea of what occurred and what sort of environment that day. I don't believe that one is right yet. And moving on, Your Honor, we had a pending motion on to permit the use of supplemental audio visual. I believe that one has been resolved to our satisfaction with the court's cooperation. We have a motion in limine regarding lay testimony, which is just a standard motion in limine that the lay witnesses can testify to what they saw and what they knew, but can't give opinions about things beyond their kin. I believe the state agrees with that statement of law. And then we have a motion in limine regarding privileged testimony.
Back to the one you
Yes,
just referenced, opinions of lay witnesses.
yes, Your Honor.
All right. That's government by Rule 701. What do you want me to determine with regard to that? That the rule is complied with, or what?
Yes, Your Honor. If you're talking to me,
Yes, I'm talking to you.
Yes, Your Honor, I thought you were talking to the state. We just want to make sure that once again, we're just, I know these are fairly standard, but we're raising guideposts, things that we think could be issues. We just want to point that out.
Now, I don't believe that this is standard to ask the court to rule in advance of the trial as to whether a lay witness can give opinion testimony. It depends on Rule 701 and what is asked and who's asking and all those things.
Well, Judge, the
I'll
motion, the motion
take it
just
as a
requests,
warning post, as you said.
yeah, that the motion just requests that the court hold a hearing before allowing the court to hear before allowing a lay person to give an opinion or to get outside the opinion.
Well,
Your Honor, we will cross that bridge when we come to it, if that's okay with you.
all right, fine.
Finally, we have a motion to eliminate regarding privileged testimony. I don't anticipate this will be an issue from talking to the solicitor, but there is a chance that some attorneys or attorneys' employees will be called if there is testimony that is adduced that was produced during a privileged conversation. We would object to that, and we will be prepared if it's attempted to be adduced to make a contemporaneous objection.
So that's the state.
We're not aware of any privileged communications that we would intend to put in evidence, Your Honor. If that were to come up, we would certainly notify the defendants.
There's one last one, Your Honor, and I think we agree to this. It's just a motion to prevent the solicitor from bolstering any of the state's witnesses by testifying to their truthfulness, and I believe they agree with that.
I think that's pretty much black letter law, Your Honor.
I agree.
So, Your Honor, then pending and still out there awaiting circumstances to make them right if the court is in agreement would be the motion in limine regarding a view of the scene, and then a motion in limine regarding the state's closing argument. And I believe the state has a motion to limine as well.
So are we aren't addressing the closing now, and what was the other one? The jury view.
Jury.
There also was a motion regarding transcripts that we are going to take up later, and a motion to exclude or limit video, which I think, again, is one of those really objections that will cross the bridge when we get to it. That's their motion. I don't think there's anything for you to rule on here today.
Do you agree?
Yes, Your Honor. Until the video is introduced, I don't think it's proper for, we'd be preemptive. We don't know what they're going to introduce, when they're going to introduce it, but it is out there, and we just want to make the court aware of that. And Your Honor, we have a motion to, we're out of motions to eliminate now in regular motions. We have a motion to sequester witnesses. Didn't know whether the court was going to invoke or enforce the rule in this matter. We would ask that they do, with the exceptions of the case agents or primary agents, any family members and expert witnesses.
Well, the rule exists in federal court and state court. It's a matter of discretion by the court. It's not automatic. And
Yes, Your Honor.
It must be a showing. Of course, if there's no objection by the state, then I typically have no position.
And Your Honor, would that include electronic sequestration, if you will? I mean, the sequestration used to mean you got outside the walls of the court, but with streaming video and all those things. We would just ask that the witnesses refrain from watching other witnesses' testimony.
Your Honor, I don't really, and as you said, it's up to your discretion. I really don't see that there's a big need for sequestration in this case, primarily because there was only 2 people out there at the time this happened, or 3 people out there at the time this happened. One of them's dead, one's sitting on that side of the table, and one will be testifying on this side of the table. It's certainly not a situation where witnesses will feed off of each other and things of that nature. There were some police officers there right after the shooting that were there at the same time. They were the only ones I could think of that sequestration would have any viability for at all. But we'll leave it up to you. I certainly don't think it should extend to experts. Certainly shouldn't extend to victims' family members, and it shouldn't extend to their ability or our ability to talk with witnesses prior to them going on the stand.
And Judge, I would not disagree with those caveats you gave. I would disagree with the fact that I do think that this case still offers, like any other case, for witnesses to craft their testimony based on previous witnesses' testimony. And I think that's why sequestration is generally a good tool for the court to control the testimony. But of course, the court makes that decision.
Well, I generally deny motions to sequester based on Rule 615 that states that the court may order the witnesses excluded so that they cannot hear the testimony of other witnesses. And you referenced it in your motion. If there's some basis to believe that a witness's testimony, I think you referenced that might be tainted listening to another witness, but there must be some showing in order for me to sequester witnesses, because it's extremely cumbersome and it interrupts the flow of the trial, and as has been referenced in various places. We have an open court, open trial, and I'm not inclined just to bar people from the courtroom absent some compelling need. It delays the trial, and you want to find the people wherever they are. It often does anyway. The delays between the witnesses. There must be some showing, some need. And as I drew the distinction between federal court, where it's a matter of right, and state court, where it's a matter of discretion, and I exercise my discretion typically to not automatically sequester witnesses. There has to be some need shown. We have a lot of expert witnesses. Many expert witnesses even are allowed to hear the testimony of other experts and then comment. You had an expert a few minutes ago who wanted to give commentary on what has transpired during the trial thus far. Someone who was in jury selection, then wants to testify about jury selection. So then you had your own lawyer as a witness. Co-counsel as a witness. Tell me, give me a compelling reason that I should.
First of all, Your Honor, this has no doubt been a long, strange trip already. The distinction, I think, is between the court having a motions hearing outside the presence of the jury and the jurors being influenced by the testimony. The jurors, as the finders of fact, are going to be seeking out those facts in the testimony. What we're concerned about is if, Your Honor said the circumstances would have to dictate sequestration, but...
And typically, the motion is made where you have a number of fact witnesses at a scene who may have observed things differently, and as the solicitor argued, there aren't many fact witnesses whose testimony is likely to be given based on what they have heard other witnesses gave. And in addition, if there is a fact witness, chances are that witness gave a statement that can be used in cross-examination and can be used to impeach the witness. And who would be sequestered?
Your Honor, I would just propose and re-urge that the fact witnesses, not the expert witnesses, be sequestered.
Both sides.
Both sides. Expert witnesses be permitted to send in testimony, because that's really their function, right? To advise counsel on other expert witness testimony. But there are some lay witnesses, police officers, investigators, and others. A lot of this case concerns, we all know what the end of this story was, and we've seen that. But what happened after that is very important to the defense's presentation. And what we would not want, that we had two different teams of crime scene investigators, both from the South Carolina Law Enforcement Division, and we had crime scene investigators from the city of North Charleston. There were a myriad of people in and out of the scenes, and we want to make sure that we get each individual story to the best of recollection on that day without being cross-pollinated by other people's recollections as the testimony goes on.
It says the state.
No change in my position, Your Honor. I don't think that there's any overwhelming need to sequester witnesses in this case. Saying that, I understand it's in your discretion, and
You want to question police officers, letter and SLED agents? Is that what you're asking? Or?
Yes, Your Honor.
and we would object.
Let you know in the morning.
Thanks, Judge. Judge, may we have a couple moments, please, so that we can maybe save the court some time later?
Yes, sir. Back on the issue of these requests to sequester witnesses, I noticed State v. Carmack, a case in which the trial court excluded only witnesses who had not previously given written statements. Are there any such witnesses in this case?
Not to be hyper-technical, but it depends on what you mean by statement. The crime
Something
scene
that's
people.
been given to the
Right.
defense.
For example, the crime scene people have done reports, and certainly that documents their work and things like that. They haven't given formal statements that are signed and witnessed by someone else. But I think all of our witnesses have given statements.
I think all of our lay witnesses have for sure.
I'm a little bit hesitant to try to tell you on the fly if somebody's giving a statement. With this many witnesses,
Okay.
I can tell you we don't have many witnesses outside of law enforcement who testify about the same thing.
Okay, what else do we have today?
Your Honor, we'd just like to raise this. These have been raised before. We have a couple of motion in limines, and I can tell that you're not a big fan. But just before openings tomorrow, we had filed a motion previously regarding any references by the defense to the character of the victim, Walter Scott. We had kind of agreed that, before any of that came up at trial, they would let us know and they would be allowed to proffer the testimony and so forth. Just wanted to make sure that that was everyone's
What
understanding.
says the defense?
The defense agrees with that, Your Honor.
All right.
Okay.
Will you be giving the opening, or are you speaking on, will you be giving the opening?
Your Honor, I will know tomorrow morning, but I
I was wondering, making sure whether you're speaking on.
I am speaking on behalf of the defense team, Your Honor.
Defense team.
Yes, sir.
Okay. And the other was to not mention penalty or punishment. I think that's kind of black letter law anyway, and I'm sure that the defense team would not go against black letter law, Your Honor.
We would not do that, Your Honor. We will not mention the punishment.
All right, very good.
One other issue regarding openings, Your Honor, is clearly from the beginning of this case, bond hearings up until today, at every turn, Mr. Savage has talked about what's going on in the rest of the country. I think it is critical in this case that the decisions of this jury be made on what the evidence is in this case in this courtroom. And we would ask that the court limit any reference to what's happening in the rest of the country with officer-involved shootings and things of that nature, especially in opening. If for some reason, unforeseeable to me, they are able to develop that testimony and it becomes fruit for closing, that's for another day. But I don't believe that what is happening and what has happened in other places at other times is relevant and right for this jury's consideration. And we'd ask that that be limited.
All right, Mr. McKim.
Your Honor, I don't know that that would be addressed at all, but I think just the concept of that flies in the face of what we've been talking about for a great deal of the testimony today. This issue, whether we like it or not, this case is framed by events that have happened outside of Charleston County. There are incidents that have formed the lens through which our jurors will view this case. I don't know whether it's relevant to the particular facts of the case, but it is relevant, very relevant to the minds of the jurors. This case is not like every other case. If that is to be addressed, or wanted to be, if we wanted to address that, and that was denied, it feeds into what we have been trying to advance all along, that we cannot carve out Charleston County from the rest of the world, that the events that happen here are unique events. And we agree with the solicitor. We want to cut this event from other events that have happened. But sometimes in order to do that, you have to address those events. And once again, I don't know whether that's intended to be addressed in the closing, in the opening at this time or not. But I don't think it's prejudicial. I think it is, if it is addressed, it is something that needs to be addressed so that the jurors can consider the facts of this case in a lens that wipes clean anything that's been going on in the rest of the United States. Because like it or not, Your Honor, this case is a bellwether case for many people. And we can pretend that no one else has heard any of that stuff and no one else cares about any of that stuff, but these jurors here all know it. They all know it. And I think
They all know what?
they all know that this case has a great deal of national and international scrutiny. And the reason it has national and international scrutiny, Your Honor, is it's a case that's sandwiched in many that came before and many that are have come after that involves officer-involved shootings. And to the extent that they look at this case through that lens that they've been provided, I believe it's a disservice to Mr. Slager, and I believe actually it's a disservice to Mr. Scott. By ignoring it, Judge, it does not go away.
Ms. Wilson?
Your Honor, again, Mr. McCune kind of makes my point. They have continued to try to frame this case on what's going on nationally and to make everything that happened that day someone else's fault. And it is important that we don't go down the slippery slope of every other officer involved shooting in this case. And I think that's going to be a disservice to Mr. Slager if we get in a position of putting up evidence, because the defense has dragged in what's happening in the rest of the country. If we put up evidence distinguishing what happened here and what happened in a lot of those other cases, it's not appropriate, it's not relevant. What is important is what Michael Slager did on April 4th, what was in his head when he did it, and what happened that day. To get into the politics and the social movements of the day is just not relevant. Maybe it was relevant for jury selection, and some of those questions were asked, and the court conducted voir dire on those issues, but it's not relevant for the trial of this case. They must make their decision on the facts here, and we must not go down the bunny trail of what decisions were made in what other places for what reasons, because it's not relevant. And frankly, the decisions of Chief Keel, the decisions of Eddie Driggers and Mayor Summey, my decision to indict is not relevant to what this jury has to decide. The only thing that's relevant is what this defendant did on that day and what was in his head when he did it.
Anything further, Mr.?
Your Honor, I would say what was going through her head when she decided to indict is very much germane to the case, because it's the reason we're here today. I would also say that the state has one victim as in this matter that is it's been televised. It's had a whole lot of publicity. Mr. Slager is a member of a class of people who have been accused because of their profession and because of their uniform, terrible things. And let me be clear, once again, I don't know whether we're going to get into this or not. I can tell you that if this were to be mentioned at all, it's going to have nothing to do with facts or circumstances or any of the underlying judicial or prosecutorial decisions in any case. That we would agree that's totally irrelevant. But we do think we need to frame the issue, and we do think that if it's necessary to frame it in terms that the rest of the jurors, all the jurors there have seen what's happened in the rest of the country, and to ignore that throughout this trial, I think would be a mistake. And we wanted to probe a little bit more the feelings they might have about this. Judge has made his ruling on that, but I think that if we ignore the landscape under which this trial is taking place, we do so at the peril of both the Slager and Scott families.
The jurors will take an oath to well and duly try the case and render a true verdict according to the law and according to the evidence. And that's the parameters under which they will be asked to serve, to listen to the evidence and apply the law and render a verdict based on the law and based on the evidence. The purpose of the opening statement is for counsel to have an opportunity to explain to the jury concerning the nature of the case and what defenses might apply or may be offered, though the defense is not required to even make an opening statement. But this case is not a referendum on what's occurred in other places. The jurors will not be called upon to base their verdict on an improper basis, that is, something occurring someplace else. This case will be based on the law and the evidence as it relates to what is presented in this courtroom. And I trust that the jurors will be able to fulfill their oath, and counsel will have to fulfill your oath as well. Certainly any thing that goes beyond the parameters of opening statement and seeking to have jurors decide this case based on what happened someplace else, the court will not allow that testimony, and certainly parties will object based on whoever's offended. Yes, sir. Mr. McKim?
Yes, sir. Just very briefly, we couldn't agree more with you, Judge, that the jurors are going to have to decide this case based on these facts. These facts didn't occur in a vacuum.
Got additional argument, objection, commentary?
Your Honor, you've been very accommodating to us today, and I don't want to belabor the point, but this event is not like the others. Our concern is that all of these are treated alike. All of these events are different. Every one of these events is different. Everyone results in their own sets of intricacies and problems and their own facts. We don't think that this event needs to be lumped in with other events, and sometimes you have to break events away.
Sounds as if you and the state agrees. I'll leave it at that on that point. Yes, sir. Of agreement, I believe. With regard to the photos that you're going to use tomorrow morning, what's
We're done, Your Honor.
Very
That's
good.
all. Thank you.
We'll be in recess till